Counsel, are you relying on 1302A?
The Secretary invoked, that's the Secretary's general rulemaking authority under the Social Security Act, and he invoked that general rulemaking authority as he typically does when he makes rules under the Act, but we're not relying primarily or on that. We're instead relying on specific authorities as to each category of covered providers that allow the Secretary to set standards that set the requirements for their participation in Medicare and Medicaid.
I don't understand what you just said.
I'm sorry. The answer is yes, but not only on 1302. We also have specific statutes that speak to each of the covered providers here.
So if I look at the language in 1302, which says that the Secretary shall make and publish such rules and regulations as may be necessary to the efficient administration of the functions with which each is charged under this chapter. You say there is more than that authorizing the Secretary.
Correct, yes.
What is that more?
So the more is set forth. It's different as to each category of providers. So take hospitals. There, the additional authority is in Section 1395X E9, which authorizes the Secretary to set such requirements as he finds necessary in the interest of the health and safety of patients in Medicare and Medicaid. The Secretary cited other similar requirements that authorize him to set conditions of participation for each of the categories of providers, for nursing homes, for ambulatory surgical centers. All of those categories of providers are subject to similar requirements that say the Secretary gets to determine the requirements for their participation in Medicare and Medicaid. The Secretary has long relied on those specific statutory authorities to set forth detailed conditions of participation that are in the Code of Federal Regulations. And what he did here was say, I'm going to add an additional condition of participation pursuant to those specific authorities for each category of provider requiring vaccination against COVID-19.
Has that been used in the past, the argument or the authority that you just set out? Has that been used to require vaccinations in the past?
It has not, no. But the Secretary explained why not. He explained that this is a unique pandemic where we have unique access to effective vaccines. So he explained that in other settings, healthcare workers are typically vaccinated against communicable diseases because they got them during childhood when all of us did, or because state authorities have required vaccinations. But this is a uniquely deadly pandemic that because it is so new, those requirements haven't caught up and ensured the level of staff vaccination that you see in the context of other diseases. And that's why he found it necessary to step in with this requirement.
One last, just a question. Don't you think it's a bit curious that you're placing significant reliance on a provision that speaks about necessary to the efficient administration to administer a vaccine that could have significant health consequences?
Justice Thomas, I don't. So first of all, I just want to be clear again, I'm not claiming that that general authority alone would authorize the vaccination requirement. We're resting on the conditions specific to each category of provider, the vast majority of which, the ones covering 97% of the workers affected by this rule, specifically reference conditions aimed at health and safety. I think when you look at it in that context, it's clear that this is a paradigmatic health and safety requirement.
Counsel, in which case is the